Oh, are y'all nominating Raquel?
I just did.
Oh, okay, so
Her name tag's not out anywhere.
the chair is out ill
Okay.
and vice chair is online and state law requires the chair or the person running the show to be in person and they've just nominated you.
You can thank me later, Roger.
So
Because I'm the last one here.
it's really easy. You just call it to order.
Okay.
You ask the city clerk's office, do we have anybody signed in to public comment? And then you say, you know, item whatever, let's approve the minutes. Do I have a motion? Do I have any corrections? You vote, and then you move on to the next one.
She's
Through this.
she's
Yeah.
she's chaired.
It's
dozens of
fine.
committees,
Most
so
people though, when you walk in the room and you say this, go, "Oh," and they forget, so. I'm
She's-
sorry.
Yeah, just I'll.
You had that shock look on your face.
Mhm.
Do you need a pen and a highlighter?
Oh, you can have these ones. I have these on.
I have a full box. I'm happy to share.
there, we needed,
We're good.
She's got extra.
Yeah, I had extra.
we needed one more person to be able to meet.
Okay,
Okay, you're the lucky
So
to make a quorum. All right.
one reason we were cheering you. Aside from you're chairing the committee.
Just your entrance, we decided to cheer.
yeah, filling in for Chris.
Would you like to have a meeting to order?
I'd like to call the meeting to order. It's 6 o'clock. First item on the agenda. Public comment. Is there anyone here for public comment?
No. Chair, there is not.
Okay. Moving to the next item on the agenda are minutes. Consideration of an action on the minutes on the September 11th meeting. Can I get a motion to approve the minutes? All right, so we've got a motion and approval. All in favor of approving the minutes, say aye. Any opposed? None opposed. Next item on the agenda is our workshop. This is where we will review and discuss proposed revisions to the Code of Ethical Conduct.
Madam Chair, I believe last time we were working on the name clearing.
Section 2, 102.
So section 2. Can you repeat the name clearing procedures? That's section 2, 102. So this looks like what has been edited up to this point. It's just changing his or her name to there.
The last meeting, you also requested that on a separate piece of paper, we put the current language and then perhaps draft something that would look like if it was an appeal afterwards. So that should be the last page in your packet.
I like that, it's succinct.
Just a first attempt, so I'm happy to make any revisions that you see necessary.
I always like whenever it's brief. Brevity is really appreciated. Especially when you're walking through page after page.
Any other comments on section 2, 102?
So the consensus is for us to move that over to the red line.
Yes.
Great. Okay. So the next item. Here's. Okay, so I'm seeing other comments referencing our 9/11 meeting.
Yes,
We're all.
we didn't get to them.
Okay. And would that be the same for really the rest of the code, right? Okay. Okay, so let's move on to section 2-103, the penalty for filing false complaint or giving false testimony.
This is still current, this ordinance?
And this, yes,
Yes.
has not changed.
Yes, 2017 was the time the original was adopted, and this section was not changed in y'all's last round of revisions.
I'm fine with leaving it as it is. How do others feel?
I concur.
All right, so section 2-103 will have no additional changes. We'll move to section 2-104, public records and open meetings. So meetings and other proceedings of the Independent Ethics Review Board will be conducted in compliance with the Texas Open Meeting Act. Requests for records will be handled in compliance with Texas Public Information Act. Pretty straightforward, standard language. We have been referencing other codes. These are not major sections of our, I shouldn't say major, everything is significant. But these are very straightforward. Any discussion on section 2-104? No? Okay,
No.
so no changes to that section. Section 2-105, other obligations. This code of ethical conduct is inclusive of and supplemental to applicable state and federal laws and regulations, including Texas and federal whistleblower protection. Compliance with the provisions of this code of ethical conduct does not excuse or relieve any person from any obligation imposed by state or federal law regarding ethics, financial reporting, lobbying activities, or any other issue addressed herein.
Like a lawyer wrote that. Yeah,
So this is
that's a
basically-
compliment.
I see this as saying that other laws will still hold up. Right. Any other points of discussion? Okay. So. Our review of.
Dr. Cook, yes, ma'am. At the last meeting, you all requested some additional samples of provisions that were not included in the code, such as ex parte communication, other language regarding investigating or refusal to cooperate, reconsideration or appeals. And just for fun, I happened to see one city that had social media policy. In Rockville, and I included that if you all would like to. Include it. And then I did include samples of things there in proceedings if you did not like this draft, but you're happy with it.
So do we all want to spend just a little time first looking at the ex parte communications?
Are there items you would strongly recommend that we strongly consider?
I think they're all very valid. I don't know that I have any that I like over anyone others. I was intrigued by the social media policies just based on your past year. And didn't know if y'all might want to think about putting that in there. Or perhaps having a separate policy that city council adopts related to that for boards and commissions.
Yeah, I'm thinking that would be like more for them to adopt, and then it would apply to everyone, not just us.
Okay,
I mean, what do you all think? I think, yeah, there should be, so there's no social media policy anywhere right now.
Loosely, there's one on city council communications on what they can have on their webpage and what they can post. If you were to put it in the ethics ordinance, it would be something that a complaint could be brought forward to you all to look at. Or it could be a general policy that city council has oversight of. It's whether or not y'all want that to be within your umbrella of responsibilities.
So how would you all like to proceed? Do you want to take on ex parte communications first and then
Yeah, let's do that one.
go back to social media?
Yeah. So if we were to do that, I guess adopt something about that, would it? Seems like they put it under, like the complaints. So I'm just looking at what part of the code we would maybe apply to.
I would recommend placing it, right underneath detailed written complaints required before preliminary review. Because you can have expired up until it's filed. Once it's filed, that's gonna be the definition.
What section is that?
I would make it a 298.
298.
Everything below that.
Okay.
I'm certainly open to placing it wherever you all deem best.
So having the details with the complaint required section first and then ex parte communications and then a preliminary review of complaints. That's the order you're.
That would be my recommendation, just because it's more of a timeline.
Mhm.
You can have this partly until you file it.
Right.
Sense.
The city of Brownsville, I like the writing in it, where it says. A member of the Ethics Advisory Commission to knowingly entertain. Somebody's complaining. It doesn't prohibit them from actually talking to somebody on the ethics committee. It's if this is discussed, correct?
Or the subject matter of the complaint. Yes.
Yes, and so in city of Brownsville B, it says knowingly, it's kind of like all inclusive right there. Knowingly communicate directly or indirectly with any person other than a member of the Ethics Advisory Commission, its staff or legal counsel about any issue or of fact or law relating to the complaint.
So is this kind of what we don't do currently? Because this would allow. Would this, oh no, it's saying it would be a violation. Oh, okay, never mind. I think if we do have it in here, I'd like that there's some examples where they have the refusal to cooperate. So city of Baytown, oh, actually, that's the same. Speaking of investigating. Okay, so it's just repeated then on page 20.
Each city has.
Consistency. I picked the city and then put all the provisions that you had asked for. The drafting style and. You can choose as you see fit.
Well, I mean, I'm gonna suggest go under 2-9A, we add, I guess, D, it'd be section D,
Uh,
where do you think it should go?
I would make a new section 2-98 called ex parte communications. And then renumber every subsequent one, so the preliminary review of complaints would then be 2-99.
Okay. I guess then 2-99 becomes 2-100, okay, okay, oh, I see, so you're saying we should have it add a whole new section, okay,
I would, I think it's strong enough to stand on its own.
okay.
I agree.
So 2-9, okay. I see what you're saying, okay. And call it ex parte communications, okay,
And thank you for giving us multiple examples, so we don't have to come up with it on our own.
yeah.
Yeah.
That's very helpful. What do you think if we start with City of Brownsville, section 38-195? As a starting point.
Sorry. Petition for declaratory ruling. Have we come to a conclusion on it, on ex parte?
No,
No.
I'm just saying to start with that, so. If somebody's. If there's a public allegation, don't they have a right to say yay or nay? And start with that, or does that come later on?
So the petition for declaratory ruling is an example of the name clearing process, and I think we just looked at that.
Yeah. So that,
But if you like that language better than this sheet, I'm more than happy to substitute.
We can go back to that.
Or on page 34 or 37. I like that wording. After a complaint has been filed, during the consideration. They're not communicating.
so that's very simple.
Yeah,
What do you find? Of that new Braunfels?
yeah. Mhm.
And then
Yeah, it's, but I think it's pretty simple.
City of Austin is also very.
Are they the same? I think, yeah, should we add the refusal to cooperate, that's under City of Baytown, except 37.
The three sections that you asked me to bring forward, or look at ex parte communication, language compelling participation, and retaliation clauses.
Okay,
But for my own notes, if we take this one first, it would be very helpful.
okay, we'll do that first.
So how are you all feeling about having just a general statement versus really teasing out some additional details? So if we were to compare City of Austin, New Braunfels, it's just a paragraph. On the other hand, City of Baytown, they do have this provision, or you're confusing that with. Ex-parte communication, that is different.
And formatting was probably not the best choice.
I like how they defined it. for City of Baytown.
I think with the City of Baytown, it's like in determining whether to dismiss a complaint.
On the other side, there's processing.
If you want to, I don't know, That's, to me, that's kind of confusing, like you're jumping right away to a complaint, or to dismissing, I should say.
But I agree with you that the city of Baytown is pretty concise. So should that be our first working piece? City of Baytown, section B. Ex parte communication.
Yeah, I'm comparing that to City of Austin, see which could be better.
Yeah, I mean.
Boston and New Braunfels were.
Very similar.
Yeah.
Mhm.
Cause
I was trying to figure out what the difference was. I haven't done it yet.
I do, there's something about jumping to dismissing, right, you know, like basically kind of defining what ex parte communication
Right.
is. You know?
I agree. I like Baytowns, but not
The city,
just as is. I think we need the.
yeah, like, yeah, Austin, yeah, it adds a little bit more, so yeah, I'm in favor of the city of Austin's wording.
Actually, does the city of Baytown, if you flip the page, there, what you're looking for is actually on the back.
Okay.
So the dismissal is on the front.
Got it. Thank you.
At the bottom of 26 of 37. It still says the
Yeah.
ethics commission may dismiss.
They're actually the same on the front and back, right? Yeah. I must have really liked it when I was cutting and pasting and put it on there twice.
I mean, I don't know why that,
Instigating a
I
complaint.
feel like some people may not know what is meant by ex parte.
Yeah, that's,
It is, you're right, it is the
I
same.
hate for
Okay.
everyone to do that.
I
just to
think I'm
have it
looking at
dismissed.
improper ex
Right.
parte communication.
It almost seems like a procedural way to get out of something
Yes, yeah.
and avoid having you go through the process.
I mean, it's under a section that is really about how to process and investigate a complaint, so
Mhm.
before they jump into number 2 or 3, they preface it with in determining whether to dismiss a complaint. So framing is, the setup for that is different compared to just having a section on ex parte communication and defining what it is and just saying you can't do it.
Right.
In which case, the city of Austin could be the way to go.
What do you think about the city of Den?
I'm looking at them. With Denton, they're distinguishing between the complainant versus a member.
Right. So that's more detail.
It's Austin, it looks like it's just about a member of the commission.
I have to say on the city of Denton, I like the inclusion of a witness to the complaints. There's no harassing there or intimidation.
So, having the retaliation prohibition is something we could include.
That was one of the 3 that you asked us to bring back. Yes, ma'am. You have a preference?
Kind of leaning on the Denton.
Yeah.
I am too. I am too.
Yeah, me too.
Did I just read it aloud so we be clear what we want? So for ex parte communications, we'll have a separate section that says, after a complaint has been filed and during the pendency of a complaint before the Board of Ethics, it shall be in violation of this article if one, if for the complainant, the respondent, or any person acting on their behalf to engage or attempt to engage directly or indirectly about the subject matter or merits of a complaint in ex parte communication with a member of the Board of Ethics or any known witness to the complaint, or for a member of the Board of Ethics to knowingly allow an ex parte communication about the subject matter or merits of a complaint, or to communicate about any issue or of fact or law relating to the complaint directly or indirectly with any person other than a member of the Board of Ethics, the city auditor's office, the city attorney's office, or special counsel. So this allows us to talk with another member of the Board of Ethics.
As long as you don't have a quorum.
Okay. But could this communication happen? Is this allowing us to have communication outside of the meeting?
As long as there's not a quorum. The Texas Open Record or Open Meetings Act would not allow a quorum maybe to discuss anything outside of a meeting, because if there's a quorum, it is a meeting. So that doesn't change what you're currently allowed to do.
Okay.
The best practice would be not to discuss it outside of the room.
Would we talk to the city auditor's office ever?
We would take that out because we don't have a city auditor.
Okay. So with Austin, it says the funders that are not prohibit a communication by a city employees with the commission in the performance of the city employees of the duty. Then doesn't say anything about city employees.
Would have the city clerk's office.
So are we comfortable not considering Austin anymore and really adopting city of Benton?
Yes.
I'm good with that.
Okay. It's perfect. And we'll just eliminate city auditor's office language and add city clerk's language to the second provision. Okay. Okay, moving along.
Yeah.
So a retaliation prohibition. Talk about that. And this has nothing to do with ex parte communication. This could be in another section.
Yes. Some cities had their entire ordinance as one section. And then some of them just broke them up in different ones. I can place it wherever you like it to be.
Okay, let's see.
Well, does it make sense to follow the ex parte?
I kind of feel like the retaliation, if there is a provision, it shouldn't be just limited to a city official vendor. It could also just be. I'm just thinking back on actually what happened, where another complaint was filed and it felt like it was more retaliation against the mayor. I don't know how much we can talk about that. But I don't think retaliation should be limited to, and maybe it's a frivolous complaint, but I'd like us to talk a little bit
Right.
about the extent of this retaliation provision. Is it only about city officials, commissioners, board members, or should we be thinking about possible retaliation if a decision doesn't go away that the public wants? Or in defense of the person for whom a complaint was made?
it's outside the realm of the city, meaning city staff or volunteers, then it becomes a civil situation, but maybe I'm misunderstanding what you're thinking of.
Yeah, I remember kind of being irked by the other complaint. Really about, it was a complaint about what the mayor didn't do correctly with how the proceedings went. And I felt like it was more retaliatory because even in the hearing, I think this person said that they were basically gonna come after them in so many words.
So perhaps maybe, retaliatory by filing a subsequent complaint related to the original complaint or something to that age. We did struggle trying to find examples
For
of
that,
retaliation.
okay.
I can certainly look at the private realm to see if I can find anything there.
I don't know if adding or expanding what we mean by retaliation can introduce more of what we don't want, right? That by it being more explicitly stated, would that encourage people to challenge it? I don't.
I will look for some more examples.
Well, let's put that on the side and we will look at, if we can find some in some private realms, didn't find very many in the city realms.
Are we looking at more examples of an expanded application of retaliation provisions?
Well, yeah, like any, said, like any of those situations where people are, don't like you say, meetings. Ratifying something, okay?
Would you like a compelling participation? So let's look at that.
Compelling participation. Which one, where is that?
Yeah. Like refusal to cooperate.
Refusal to cooperate.
And find more luck on that.
Sure.
Or more like I found it twice.
Daytown.
Twice.
Yeah, I think that's the only one.
Must have liked it.
I apologize.
We'll get over it.
That it requires another section? If we could apply. So the question is, could it be integrated into?
I would probably put it under, current 299, which would be 2-100A. Oh, that's, I'm sorry, it's not me, under yours. Under the public hearing, 2-100.
Yeah.
So what if the complainant refuses to cooperate, but there's a sense that there's legitimacy to the complaint?
This is not mandatory, it's permissive.
Okay.
So if the board wants to continue on their own, you may still do so, but you can also say because you filed this and you will not participate, we can't get sufficient information. Your failure, so you don't even have to come to a yes or no, but your failure to assist us in this, or your failure to provide enough information, we're gonna dismiss it. But it's not mandatory, it's permissive,
Okay.
and so if you look at it and you go, wow, you can direct staff and we can get you the documents that you
Okay.
may need to be able to investigate it if the person doesn't cooperate.
Okay. Does that need to be stated, or is it pretty much assumed?
I think May is sufficient,
Okay, May, May just, okay.
but I'm happy.
No,
As long
that's
as this is
fine.
your
No, that's
ordinance.
fine. No, that's fine. That those fine little words that. No, that's
It's not a
not
must, but
Read the Smith,
Can we not have anything like that in the code? Oh,
so it's probably a good thing to have.
no, I agree.
Yeah.
It sounds familiar though to something that we discussed, but
Mhm.
Any harm in taking this as is from the city of Baytown?
I would just take where the investigating attorney out. Because we don't have an investigating attorney.
But other than that, the language seems pretty straightforward.
Yeah,
I can add the red line under the 2-100 for y'all's review at the next meeting.
okay.
So what about 2-99? Just curious what. So I'm looking at circumstances where we might dismiss a complaint, so this was this because it wasn't reflected.
Where you could put it under 299. As a bond.
Yeah, they're not cooperative.
I think that's a very good place, actually.
Yeah, let's make it a 5.
yeah, I agree. That's what I was thinking of before,
Okay.
okay.
Yeah, perfect. Thank you.
It seems like it should have been there, but yeah.
I knew I wasn't making it up.
Does it need to go in more than one place or is that sufficient? Because I'm thinking about the public hearing. So let's say. We dismiss it, we haven't dismissed it as frivolous, but we're gotten to the stage of a public hearing and they're not.
Do they have to come to the public hearing?
And
So they-
that's you, compel them to. Well, I guess this is, you could compel them and you could require it.
You know, they can cooperate and then say, I don't want to come to the hearing.
You know. It's not necessarily, in my opinion, it's not necessarily frivolous. But, I mean, it's. I think we need something in there, but
Make it as a C
Instead of a 5.
and then read letter. I can do that as well.
Yeah, that's true. It's not really frivolous. Yeah, you're just dismissing it because they're, yeah, yes, maybe make it a C.
even its own letter.
Okay. That then addresses your concern about putting it in the public hearing. Or do you want to put it
guess-
lower than C, because C is your entry level review of, do we think this is enough to move forward?
Right.
Do you want it to be before that, or do you want to put it later in your process? When do you think it would apply?
I think it would apply just perhaps more in the hearing, but
I mean, it's,
if they're not cooperating and maybe it's not just a.
it says right now, the way it's worded, under public hearing, D, the complainant has the right to attend the hearing, the right to make a statement, the right to be accompanied.
So it's not, it's not.
Not like something required.
Yeah.
I want that girl. I was thinking more of when you're not cooperating, say, when the hearing is actually going on and we want to make me feel certain that that's not listening. Could we then have the right to say, well, you're not cooperating in the proceedings of this hearing? And have reason to dismiss.
In that case, I would suggest putting this as a new E. So that you have C, where's your preliminary review of whether or not to move forward with the hearing. And then you could dismiss it at the preliminary hearing in D because there's not enough to move forward. And then you would have this as E, refusal to cooperate, then you could dismiss it. And then the current E would be an F. So the order would be your preliminary meeting, go or no go.
Right.
And then you would have, okay, here it is. Now, we've given you information and we're gonna move forward. They have to cooperate at that point or you dismiss it.
Right.
So that would tie it to the flow. So that would, instead of being a new C, it would be a new E
And you.
with that.
Okay,
Rolled into any other change. If there's a better place. This is
That makes sense. Look, it's almost like chronological.
Do you all feel though that there is a need to address possible retaliation during the hearing? Not, lack of cooperation,
Yes.
more than what we have. So we'll add that as another section under, subsection under 2-100.
if you had a lack of cooperation during the hearing though, wouldn't that just? Is that a basis for dismissal or more of a basis for? Having a no verdict, if you will. I mean, a verdict of no, not a no verdict. Does that make sense?
Dismissal. It does make sense. But in order to have a no, you have to have all the information, either a yes or a no.
So you dismiss it for lack of evidence.
In that scenario, but what if the evidence is sufficient, but they're just not cooperating in terms of just maintaining, helping us to maintain order in the meeting? That's different, right?
That goes back to your discussion last week, when you talked about adding language to the script for the chair. And if you can't behave, we kick you out of the room, or type language. That gets more to a behavior as far as you're not participating, correct, that would actually be disruption of a proceeding as a class B. Could be a class A depending on how bad it is. That's pretty impressive. So it's a little bit different. That would be a criminal charge for disrupting the meeting proceeding, whereas this is, you filed this, now you've got to, give us the information so we can move forward.
It's an act of omission rather than commission, so to speak, because you didn't show up.
Or they show up and they don't
They're not
participate.
participating or it's what you didn't do.
You filed the complaint, then you just sat there. And it goes back to more of you wanted the fanfare, the publicity, you wanted somebody to be uncomfortable as opposed to you think there really was something there. And then you all would sit there and decide, well, based on what they have given us, we do think there's information that we need to look at. And staff bring us this information. And your outside counsel would talk to you of, this would be kind of information you would need to move forward or dismiss.
So are we still agreeing to have a section that addresses lack of cooperation in a public hearing? Cause then what you were talking about with the script, that's not gonna be actually integrated into the code.
It is not, it is, we write that out, we take the meeting order, we talk about reading the different, when you swear people in and that sort of thing. And then it walks through the discussion. Is this sufficient evidence? Is this, and that sort of thing.
Okay. So if it's not, then I suggest that we do have it. If y'all feel the same.
I'm good.
Right, so another section will be added to public hearing that deals with lack of cooperation at the hearing. And then do we want to talk about name clearing proceedings? Would that be the next one?
I thought we did that on the regular.
Yeah.
That was what we
Oh, I'm
did
sorry,
first.
the very first one.
But as you look at these other cities, if you like any of their language better. Let's say, well, actually, or we could stay with this one. And this is a little bit different than the one here. Because the direction you all gave us was, what would a rule tool name clearing be if you somewhat incorporate an appeal? And so I was trying to capture my confusion at your last meeting as to what you were all looking for.
And it looks very similar to Pearlands.
Be very, very slow because that's where.
It's exactly, yeah. Yeah, I think it's still, the way we have it, I'm still about with keeping it that way.
The other item that was mentioned would be an appeal or a reconsideration and whether or not you wanted language, repeated but barring claims again. You can't bring it back a second time. But I did put a little bit of
El
example.
Paso had a reconsideration. On page 32.
And so does San Antonio.
And
Similar charges barred.
intention too.
I think the difference is the 14 days versus the 30 business days.
Or that they actually, 5 business days, they have to get within 5 business days of receiving the final opinion of the ethics board. That's San Antonio. And Denton's 5 business days.
Mm.
Yeah, but it's like Denton and San Antonio. Some similarities. And would this be, I guess, a new section 2? Meredith, like maybe above name clearing procedures or?
I think that would be that.
Yeah, I think we should do something.
Actually, I would put it between public hearing and sanctions.
Okay.
I think it could go either before or after the sanctions. Chronologically,
Right.
because if you don't do sanctions, they wouldn't have a reason to appeal.
Right, that's true.
My vote would be for between sanctions and the name clearing procedure.
I'll go for all passes on this one.
What do you like most about El Paso's?
It's concise and simple, and it didn't have with the chairperson having sole discretion, and I think that's pretty dangerous is the right word.
We would be locking ourselves in.
But
if we limited it in that way.
I think 14 days is reasonable between the 5 and the 30. 30 seems like it's dragging it out too long, and 5 seems it's too fast.
We want it to be 14 working days, you saying working days in the document.
So business or calendar, you want business?
Yeah. I mean, that's what,
So it's consistent with.
yeah.
So we've got a new section, mirroring El Paso for reconsideration that will be placed after sanctions. For name clearing.
Do we want to add anything like San Antonio says, if the panel concludes reconsideration is warranted, it shall bring, we want to bring in anything there or just go to usual procedures?
Well,
So that it's on page 35 of 37.
Yeah.
It's like halfway through that reconsideration paragraph. If the panel concludes
I see.
reconsideration is warranted, it shall bring the request within 10 business days to the full board.
The difference between you all and San Antonio is they have a preliminary board that does the go, no go, where you all do it as a panel. So that
Yeah.
they're, when you all decide go or no go, I would recommend doing the whole thing and being done.
Okay.
If they want to appeal
We
it,
don't have mid-management.
Okay.
I would think that if they want to appeal it, they come at that moment and you decide, yes, okay, I'm granting your appeal. We're gonna have the hearing now because you've given us this new information.
Okay.
Because you've already tried it. You already have all the facts. They've got to tell you something, have that appeal. You're gonna say yes, we appeal or not appeal.
Bring new information.
Yeah, they have to give you that information at that meeting for you to say, okay, based on this new information. I don't know that I would separate it to a second go, no go, oh, you're right, this is new information, let's try again. I would say, okay, we've heard your new information, now let's deliberate.
Okay. Instead of recycling through the whole.
That would be my recommendation because you've already heard everything.
I agree.
So are they coming and telling you anything at this appeal that will make you just change your mind?
Mhm.
And so they've appealed it, now they have the burden of proof. And you go from there. That's my recommendation. Now, if you wanna have the two, that's fine.
No, I
Well,
like really
or
want
not.
Yeah, yeah.
What if in the case, reconsideration happened after the hearing?
I'm not sure I understand.
So they're not satisfied with the outcome. Because what you've just described would be a decision being made on the spot, and they would request that we reconsider because new information has been provided. Right, so if it's.
And they have 14 days to get that submitted.
Yeah, that's the definition of reconsideration.
They have to
But-
bring new
but-
evidence.
The burden is on them to bring new information or evidence. Otherwise. We're done.
So
They
then-
can't just say, hey, I don't like your opinion. I want you to think about it again.
So El Paso is saying you've convicted somebody, even those sanctions, and they say, I don't agree. You didn't think about this. So they come back and they appeal it or have a reconsideration and say, I want you to lighten my sentence for the following reasons. And then you all go, okay, thank you for bringing these forward. We're gonna deliberate on whether or not we're gonna lighten your sentence or not.
Okay,
So it's, if you
I thought
dismiss
you were-
it, someone's not gonna come back. It's done.
got it.
But if you sanction them, you found them guilty, the person who's found guilty has the right to come back. If you adopt this, and or if council adopts this and says, hey, reconsider it, I want deferred adjudication instead of jail time.
And I guess I was just thinking of the scenario if someone wanted to reconsider as the decision has been handed down. As before, I guess, not. The scenario where the decision has been made, we're all doing our thing, and then they come back and. Request reconsideration. It was more if, as the decision is being handed down and they wanted us to reconsider as the hearing is happening.
I think as the hearing has happened, they should be bringing that information up in there.
Yeah. Sure.
You sure you don't want to be right here? To keep you?
Oh.
I
I
think
gotta
that-
talk to my husband.
I think that's why it's good that it comes after the sanctions,
Mhm.
because it's like the sanctions have been delivered and now they're coming back with new.
Yes, that's a very good point. Okay. Oh, social media, that's the only outstanding thing. Like 4 minutes away. Almost be done. Do y'all want to discuss social media or defer until?
That wasn't on your list. I
I
just
know.
saw it and thought it was interesting.
Wow, we're gonna really.
I thought.
Not tonight.
I thought you all at the beginning said, we'd prefer this to be a council policy and not within your.
I think so. I can't imagine we'll be like the social media police now, that'll be like under,
Totally agree.
like.
But the ethics code does govern how all the other groups govern when it comes to ethics. So if they see it here, would it then, it doesn't necessarily mean it has to go in all the codes, maybe.
I guess, yeah, I have to look at some of these policies,
Yeah.
because I'm like, what part of social media you? That's not already, I thought we changed some of the wording to add that, for media, I think didn't we add that?
Yes. We did.
Yeah, that's true. Yeah.
It was just a freebie. I saw it and thought it was interesting.
I mean, I think there needs to be a policy about social media, I mean, it's just gonna get bigger and bigger. More influential and. Conflict of interest and. I think it applies to every. Be responsible.
That's really, I guess we can review
Right.
what's been provided and see if it has if it fits. for
I will tell you, it is the only place I have seen that included in an ethics code. I had not seen it anywhere else. It's always been a resolution adopted by city council. I just found it interesting. I'm happy to put that on the city council's work list. Adopted.
I do agree with you. I see your point. I'm also just seeing that there has to be some adherence to this. So. More to discuss in at the next meeting.
You know, or try to build it into one of the current violations. They have the general rule that you have the right to speak as a private citizen on matters of public concern.
It's the First Amendment. Which hat are you wearing?
Yes, I know.
So we are 1 minute away from it being 7 o'clock. Are there any final points of discussion before we wrap up?
It's good.
Good job.
So we did it.
Good job.
So I move that we close the meeting.
Second,
Thank you.
all in favor, leave.
Do we need another meeting or we're done?
You're gonna have to review the red line so that I know what to take to city council